Uganda?
Yes.
Soka mu Luzungu kuba it's official.
Nsoke mu Luzungu.
Waliwo omusajja atwali eri akyateeka muzinga gwe mizairo ye kasooka agiteekeyo eyaba sniper. Aba tannaba sinza nasoma amana atamanyi munasoma. Fine.
Yeah. Thank you very much. We came here to witness the proceedings of the case formed that our leader is not in position to come. And he has objected to coming to this court because we are pursuing the project of fair trial. Fair trial in which the accused must have a fully constituted legal team of his choice. A fully constituted legal team of his choice. You know that notification was given to Justice Baguma in the previous proceedings that unless fair trial is handled expeditiously, and in that way it means that the accused must have their legal team well constituted as it was, with Martha Karua as leader of the legal team, with Arias Lukwago as the deputy leader of the legal team, with the legal team ceasing to be intimidated by the forces within the executive, within government, particularly by the CDF. That was the bedrock for the proceeding of this court. Nonetheless, Justice Baguma decided to fix this matter today at 9 a.m. Most of us were here by 9 a.m. and it is coming to 1. There is no proceeding, and I hear there has been a meeting in which they have deliberated. Number one, they have discovered that Dr. Besigye objected to his coming and they cannot just force him. Notice had already been given. Number two, Justice Baguma was so afraid to continue to preside over this court when Dr. Besigye has his supporters to morale boost him. I hear when we sing that we shall overcome, we shall overcome, we shall overcome someday, he's so threatened and he's so exposed that he fears people to sing in court. And therefore instructions were being given that those who are coming to witness the proceedings should not sing in court. Something which we think is also unbecoming and contravenes human rights of self-expression. So, court has not proceeded. The accused have not been in position to come. There are certain rulings that were given on ECMIS in respect to the case of the human rights abuse against the CDF and the two others, which was determined by this court, of which we would need to consider going further on that because we don't think it was a fair ruling. So that is what has happened today, and we are waiting for their new strategy. But as the leaders of PFF, of which our leaders have been incarcerated, including Dr. Kizza Besigye and Obed Lutale, including Arias Lukwago, who is our national chairman, we have this to say. Number one, it is not incumbent upon one judge to determine whether this case would be determined by him or any other judge, especially that objection had already been given, that under the current Justice Baguma, no justice will be dispensed to Dr. Kizza Besigye. And I think this case is causing a lot of legal and professional encumbrances to Justice Baguma. And we would have advised him to let go this case before his profession is badly darkened because it is looking too shabby for him all the time. In this court, search has been done of who is supposed to receive a request by Dr. Besigye and Obedi Rutare, who should be able to give the record of proceedings in which Justice Baguma gave a ruling about the dismissing the application against Mr. Muhoozi Kainerugaba on human rights abuses. And everybody doesn't know how to proceed, giving dates and holding meetings about simply receiving legal documents. Simply receiving legal documents. This is the Supreme Court. We are in the premises of the Supreme Court. The Court of Appeal is here. The High Court is here. Therefore, we think that justice must be dispensed. But even receiving documents, requests by an accused person who is in prison, people do not seem to want to receive them. It looks like everybody is intimidated. Clerks, secretaries cannot receive documents. This is so unbecoming. This is where justice must be dispensed. If at all clerks, if at all secretaries, registrars can be intimidated and that they cannot even receive documents for processing them into getting a record of proceedings, then where else should we expect a population that is not intimidated, a population empowered by the law to carry out their work? This is something that we condemn in the strongest terms possible, and we want to appeal to those people working here in this kind of space, in this kind of esteemed space, where we think that everything is done in a just way, that nobody should be intimidated under this kind of space. We want to appeal to them to stand their ground. It is their responsibility and it is their right to practice what they studied, to carry out their responsibility without being intimidated by anyone. Receiving documents from anyone should not cause any kind of threat to anybody's existence, employment, or safety. And it is only carried by those who can understand that it is their right. They have the right to practice what they are employed to do in order to carry out their responsibility. And nobody is going to do their responsibility apart from themselves. It is themselves that are embarrassing. It is them who are embarrassing themselves. This is what I want to say. Mwe abagaana okureceiving empapula zino twaza fe abantu aba bulijjo tubalaba nti Katonda yabayamba ne mubeera mu bifo nga bino. Tulina essuubi nti buli muntu asobola bulungi nnyo okukola omulimu gwe bamuwadde awatali kutiisibwa. Ne bwe bibeera ng'obuwandiiko okusaba record of proceeding nakyo kitiisa secretary, kitiisa registrar, kitiisa clerk. Kakati olwo baani be mulowooza abatatya? Kitegeeza nti ekifo kino kye tulimu kijjudde okutiisibwa okwa waggulu ennyo, era tewaliwo muntu mulala agenda kubalwanirira. Ffe amaloboozi gaffe gavuddeyo, mwematize mu mutima nti musobola okwerwanako ne mu standing ground yammwe ne mukola ekibasasuza ssente mu spacing eno ey'ekitiibwa. Olunaku olwaleero twaze essaawa 3 nga tulina essuubi nti omusango guno gusobola okugenda mu maaso nga bamaze okukola ku ebyo Dr. Besigye bye yasaba. Dr. Besigye yagamba Justice Baguma okuggyako ng'ensonga zino ez'obwenkanya nga tetunnagenda mu kuwozesebwa nga zikoleddwako, tonsuubira kujja wano. Osobola n'okugenda mu maaso n'osala omusango n'ogunsalira gw'ogugwo ne wejjako ekikwa kye baakusiba. Naye nze okujja mu kkooti eno kikafuuwe okujjako ng'ensonga zino zikoleddwako. Ekintu ekiyitibwa fair trial, kwegamba kubeerawo n'obwenkanya nga sinnalamulwa, ekyo kyetikka bino wammanga. Okusooka kyetikka okubeera nti nze avunaanibwa abampolereza, ttiimu y'abampolereza njeerondedde era nga njikkiririzaamu. wetwogerera nga team defense team eya Dr. Besigye bagikubamu debituli bakuba baddira eyali agikulembera Martha Karua ne bamuzaayo e Kenya ne bagamba totekwa na kujja ku ttaka lino teweetaagibwa. Owokubiri ye national chairman w'ekibiina kya PFF Elias Lukwago naye ne bamukwata ne bamuteeka mu kaduukulu. Ekyali kigenderera mu ekyo kwe kukuba ebituli mu defense team ya Dr. Besigye ne Obed Lutale. Kakati bwe wabeera nga waliwo omuntu agootaanya omusango guno okuwulirwa amangu ye gavumenti ye kooti. Luli twawule President Museveni ng'agamba Dr. Besigye tayagala bamuwozesa. Dr. Besigye ayagala okumuwozesa naye nga enteekateeka eggondera amateeka ku muntu avunaanibwa okubeera ne ttiimu gye yeerondedde era gyakkiririzaamu nga kigobererwa kiri mu mateeka. Gwe togenda kusinziira eri mu State House ogende nti muggyeko balooya bano na bali olowooze nti ojja kumuleeta mu kkooti. Mwanguye fair trial omukulu ajje awozesebwe. Ekyomukisa omulungi eri mukulu Baguma gwe twagala okuwaamu amagezi kintu yakiva mudda kuba kimuswazizza atya yatandika dde okutya atya n'ekisiikirize kye atya n'abajulizi buli kyakola kyonna kimusudde mu ntata professionally. Simanyi wajja asobola kupracticing amateeka mu mbeera eno eriwo ali ku record okukola buli kintu kyonna ekivvodde amateeka ate nga yateeka okubeera ekitikkiro kyago. Olwaleero wetwogerera agaanye okujja mu kkooti mbw atya ti abawagizi ba Besigye abamuzaamu amaanyi bajja kumuyimba era mpulidde nti n'okuyimba wano bakuweze. Kati Dr. Besigye ffe batasobola kubeera balooya tunamuzaamu tutya amaanyi omuntu gundi Baguma gwayagala okuteeka ku kalabba tunamuzaamu tutya amaanyi asobole okubeera ng'afuna n'amaanyi agajja mu kkooti n'okwewozaako ffe tuteekwa okumuwagira. Kakati yagaye nti temuteekwa na kumuwagira ndowooza olaba ebyo byonna bibeera bikolobero ebibi. Kakati eyo fair trial bwabeera nga baagala fair trial bakomyewo Martha Karua n'ebibaluwa bye bamuwandiikako babimuggyeko. Ekyokubiri ne Lukwago bamute ajje yeeyunge ku ttiimu gye babadde bakulembera omusango gwa Besigye gugende mu maaso. Ekyo kye kitwagala kyokka. Kirabika nti ekitongole kino ekiramuzi kyekibadde mu meeting n'abakuumaddembe n'abantu abatonotono era ku ttiimu zaabwe era be batubuulidde nti ne Dr. Besigye tajja kujja newankubadde twabadde tukimanyi nti okusinziira ku kubeera nti Lukwago akyali mu kkomera ne Martha Karua tebamuggyangako kye bamuteekako ekya persona non grata nga tebaliiwo. Dr. Besigye tetulowooza nti waliwo omuntu ayinza okumugamba nti jangu mu kkooti nga ttiimu ye teriiwo kubanga ebyamateeka abimanyi ebyeddembe ery'obuntu ery'ebyobuyange abimanyi era wano ebibuuzo byabadde asoyasoya omulamuzi Baguma mumulabye nga adduka ne mu kkooti nga bimusobyeko obungi n'olwekyo nga kizibu nnyo okumukkirizisa okumala gajja mu kkooti ng'ebyo tebiriiwo.
Tulaba nti nga 50 naye kati ababiri baba nga tebaliiko nasalawo okusigala mu kkomera kiba tekimukusa waliwo balooya abalala baba
20 ng'obaleeta mu kisaawe nti nno bazanye kubanga olina goalkeeper 20 buli ttiimu muteekwa okubeeramu abazannyi b'amateeka era buli munnamateeka ali mu ttiimu ya Besigye mpiki ku bwayo buli omu akola omulimu ogugwe buli omu akola gugwe. Abalala bawandiika biwandiiko abalala be bavaayo ne boogera abalala beetegereza obulipo bwe baba bateze abalala ne bategulula obulipo bangi naye buli omu alina ennamba gy'akuba buli omu alina ennamba gy'azannya. Kati gwe bw'obeera ng'ogijjeewo oba oleesa amalibu mu ttiimu eyo n'ekigendererwa kyo bwe tuba nga tukitegedde nti ekigendererwa kyo kyakukosa ttiimu yaffe osobole okutwala omuntu waffe omuteeke ku kalabba eyo tetujja kuwerekerayo. Era bo bennyini be balwisa omusango guno okugenda mu maaso. Naye munnange reverse psychologist ali Mwami Museveni yagamba ate Besigye tayagala kumuwozesa Besigye yaga kumwozesa naye kakali agende mu kooti nga ttiimu yo gitaddemu amalibu tekikola era neteeka bwerito bwe liri kye tuyita fair trial. Omuntu ateekwa okubeera ne ttiimu ey'abameza adduse bamubuulira amazima gateeka okuwaako ruling ne mumulaba nga adduka ne mumulaga nnyo ga lubindi ezibalemesa okutuuka mu kooti. Muteekwa okwerwanako ku kintu ekyo, naffe tujja kulwana okulaba nga mubeerawo. Justice tasobola kubeera mu nzikiza, nedda. Justice ateekwa okubeera mu lwatu era mutukoledde omulimu gw'amaanyi okulaga Uganda ebigenda mu maaso. Kubanga ab'amawulire temuba kubaawo oba oliawo ne bandibadde batutwala dda ku kalabba. Ne bwe mubeerawo ne mulaba omulamuzi nga adduka emisinde kubanga Besigye ayogera gy'ali. Abantu nga bategeera nti wano waliwo ekizikiza. Kakati ebyo bituyambye nnyo era twagala okubeebaza ne Ssekwebaza yenna mugende mu maaso n'omulimu ogwo. Tetujja kukkiriza kubagoba mu kooti kubanga naffe tetusobola kwogerera mu kizikiza ng'abantu tebategedde bye tukola. Tetugenda kukkiriza kuwaayirizibwa. Kati omuntu ayinza okuva eraga lulume yayogedde bwe kiti ne bwe mubeera nga weemuli nga mubikutte nga sirina kye nayogedde kibi muba mubikomyawo ne biwolereza n'olwekyo mulwaniridde eggwanga. Twagala okubeebaza ne Ssekwebaza yenna era tetugenda kukkiriza bannamawulire kubagoba wano. Namwe gwe mulimu gwammwe okuggyako nga bagaddewo media houses zammwe nakyo era tujja kukirwanirira. Mwebale nnyo.
Chairman wa PFF
bwe yali agenda owa CDF ebiwandiiko lwe baamukwata engeri
ye musajja gwe oli mu kusala ku kamera z'abanno.
Ekyo kyo yakyogera lunye kiri ku rekodi ku nsonga zino z'oyogeddeko rulings eyakola. Atuwe court record, atuwe ebiwandiiko ebibye bye yawandiika bye yawuliriza okuva ku nju guma kyasalawo wano kisobola okubeera appealed mu kooti eddako. Kati ffe twagala okumutegeeza teyeetaaga kwesiba ku bintu bino bimmalako eddembe lya bwereere. Yaweeyo ensala bwe yali tugende mu kooti eddako ye tumukuba amabega afune n'akalembeeza afune eddembe lye okumuŋoola oba okumusongamu omumwa. Talina ddembe justice oyo talina naye nga yabyereetedde. Kakati aweeyo record of proceedings ffe tulabe ekiddako ye tumukuba amabega tugende mu maaso. We have heard that in the meeting which they had this morning, they don't want to see journalists in this court. I hear Justice Baguma feels so embarrassed and he fears the camera. It is, these are things which he has created by himself, transparent manner. There would not have been these cameras and to depict him as a man who runs away when an accused person is speaking to him. And those were embarrassments. I hear he's trying to forbid those people who are okay. And when we say we shall overcome, they feel that it is them that we shall overcome, and they are so embarrassed.
And they fear that one day.
And they fear one day when we shall have overcome them. So I hear they don't want us to sing. I don't know what they want to do when we sing. Whether we shall be arrested, I don't know. We are going to study what kind of crime shall we have committed against anyone, if at all we sing to encourage our hero. Even Jesus Christ was morale boosted. Before he was crucified, he became stronger. And I think even Baguma, one time when he's being tried in the courts of law, he will need very many relatives to support him. I don't know if at all he will have supporters like Besigye, but he may be his relatives. They will need to encourage him. So, Justice Baguma, let us be clear. We want our freedom to express ourselves. And we can express ourselves through our words, through our presence, through what we say in poems and in songs. It is our right to express ourselves.
Ngojea Ramadhani inakuwa ni heshima na hapo na pesa yao.
We were informed that they might be coming in.
She attended the meeting, probably. last time when we were here.
Case number 335 of 2025, Uganda versus Dr. Kizza Besigye, attended to RO stroke 12743, Captain Nicola Delishoya.
May it please this honorable court, I'm Thomas Jatiko, Assistant Director of Public Prosecutions. And I'm appearing together this afternoon with Richard Biri Vumbuka, Chief State Attorney. My Lord, the three accused persons are present in court. However, my Lord, the counsel representing the accused persons are all jointly and severally not present in court right now. My Lord, this matter was adjourned to today, the 13th of July. The prosecution case, as per the ruling that we received. And my Lord, the prosecution is ready to proceed. Not, they are around, not inside the court here, my Lord.
I'm seeing here comes a sim.
In our society, we receive several petitions in this matter.
You are not here.
But the first member of the faculty concerning Senior Counsel Martha Karo, who was personally conducting this matter.
What I'm asking, I put you on record, I go to the accused person.
You can put that on record and then you go to.
As the person representing them or what?
We are not representing.
Then I go there.
Yeah.
Why is this still
I know that I'm still on handcuffs.
You let them remove.
I came here by
Let
duress.
them first remove them. You will restore. Remove the handcuffs, then he addresses the problem. So kindly help court on the issue of legal representation, why they are not here.
Yes.
Legal representation.
As Judge, when we were last here on the 3rd of July this year, we did address court on the challenges of our representation and that we had filed an application number 248 seeking the remedies relating to our representation. That was not responded to. And actually on the very following day, on Saturday, on Saturday the 4th, Mr. Museveni addressed the country touching on the matters before this court. In his long address, the long and short of it that I did related to our case, is that there is indigenous community justice.
Let me first get the reason why the lawyers are not here.
I am explaining the background to that.
No, the matter was coming for hearing today.
Yes.
So tell me why the challenge you have for legal representation, why they are not here. I want to capture that.
Yes, so I'm talking about the reason fair hearing, which requires us to be represented by lawyers of our choice. But the reason I'm referring to what? Yes.
The reason is a fair hearing
Yes.
by the lawyers of your case.
Through a representation by lawyers of our choice. And the reason I was referring to what was said on Saturday Yes, there is.
Maybe now.
And that is the subject of the application we made to this court on application 248. Right. That indeed, in spite of what the representations we made here on the third, which included three main points. One,
This application is about what?
three main points. The application is mainly about legal representation. But beyond that, I addressed you on the question of us receiving the evidence that was given to our lawyers. It was read a letter was read in this court on the 3rd. To hear the disclosures. That letter was written on the 2nd of July. Which was read in this court on the 3rd.
Are you saying still there is a challenge to access the facilities?
Of course. So, up to today, we have not, because that is related to our legal representation. We want to hear the evidence together with our lawyers. We haven't had the opportunity to do so up to today. And I made this very clear on the 3rd.
So kindly be specific, the challenge with legal representation, why they are not here.
So you want to listen to the application?
So it is in that
It
application?
is in the application.
The 248.
Absolutely. That application was even touching on the earlier application, 227, where we never served the respondents.
So you are saying there is
That
one
application,
thing-
you gave a ruling even before we served the correspondence and the respondents in that application. Application 248 was actually also seeking for substituted service so that we could serve the respondents in 227, in the application number 227, which now has already been ruled.
So you are saying that now there is that one pending, 248.
So there is application 248 pending. There is access to the disclosures, which we have never had. And we had also requested, the third issue we had requested, for a record of proceedings,
For which one? Because the records are meaningful.
a record of the proceedings so far
In the name.
in the main case. But in the main and in the application that we have made. 7 items that needed to be dealt with in the preliminary hearing.
So let me know those challenges you have in legal representation now. What are you requesting?
So, our request, which I made even on the side, responded to, is that our application 248 be heard, so that we can resolve the question of representation. Once the question of representation is resolved, we shall have access to the disclosures. Hopefully then, in that period, we shall also have had the record of proceedings, and we shall be ready for trial. Nobody wants to stay in prison. And this is why, Mr. Judge, the address of Mr. Museveni on Saturday the 4th is critical also in this case, because he addressed the nation, the whole country, on our trial. And on something totally unknown to me called the indigenous justice system.
Doctor, we need to know, let me first conclude the challenges now for commencement of the trial today. So I have seen
So the three,
there is a pending application,
yes,
the record of the proceedings,
and the disclosures which follow on the representation. And these are not new demands. They have been before this court in writing and orally.
so let me get this. The disclosures which were made to your lawyers, are you saying you want also to be made to you?
They are for us. We haven't received them because we need facilities to do so. And that's what I was complaining about last time, because we made representations to court, they are totally ignored, and matters continue as if we did not say anything. And that's why today we have said no. And we wrote a letter. Unfortunately, that letter I think also was detained by the prisons. We wrote a letter on Friday last week expressing further our dilemma. Having received the ruling, I think that day, saying that the hearing was to begin today. We wrote a letter on Friday. I doubt that it is yet before court. The prisons have it. So we have challenges in prison, we have challenges in court.
Can I hear from the rest? Thank you. It's the same.
Well, I wanted to address you on this, the environment that has been caused now by the address of Mr. Museveni on Saturday on this case, because it is before you.
Let me first listen the challenges for hearing today and why the lawyers are not here.
And then I will come back. No
I
problem.
must resolve that.
No.
Then, this is it.
I want to be very brief. Most of the things have been said by everyone. But I want to talk specifically concerning myself and possibly why the lawyers are not here. The last time we are here on third,
The reason why the lawyers are not here is
when we were here on third, you promised to give a ruling of that day by 8. As I talked of now, I've never received any.
I've never received
The ruling of that day. And even coming to court, I was just told today by 9.
what the ruling they application.
You promised to give
Yes.
ruling on that day.
They didn't get
I
here.
did
Did
not at all. And for today's hearing, they did not tell me that I was coming for hearing. They just informed me that I'm coming to court today at 9. I had no idea that court would be there today. And therefore, I have never contacted my lawyers. And I'm not sure whether they are also aware that court was supposed to be there today. So, to tell court why they are not here, I'm really not in the position. Because personally, I never knew there was court session today. It's made clear that next time, service of such should really be done to all, so that we can prepare. But in addition, there is still also need for me to have access to the facilities, and so that I can get to understand what is in the disclosure.
But you have given us,
we still want to say,
yes.
maybe, I don't, you go ahead. So
Yes. Mr. Kadi, the reason
just a minute.
again, all these touches on the fair here, you know,
I'm giving you another chance to address court on the legal representation, which is affecting today's hearing. So that I'm able to respond.
I have addressed court regarding the legal representation.
Yes.
I want to address court regarding
challenges you have for hearing.
Precisely, this is a challenge for our hearing. Because statements that were made touch on this hearing.
That one I have captured that.
Yes, so let me tell you what they are.
No, you can't go to that address. So I need to know the challenge you have told the court.
That is a challenge. The address is a challenge. Because it's an address to the whole country, it affects the nature of this case, it influences the assessors, it influences everybody in this case, including yourself.
So I am saying that the challenges of legal representation.
The challenge on this fair hearing before you.
I have captured that.
So you can go ahead and address your need.
You have addressed both of the challenges of legal representation today.
Yes, I'm not addressing you further on the challenge of legal representation. I'm
Today we
addressing
are
you.
here for hearing.
I'm addressing you on what Mr. Museveni said on Saturday the 4th, which has
The
strong.
issue before court to resolve is legal representation, the challenge you have. Okay?
So when do I raise this?
You said there is application. You want me to listen to the application in court? You said there is a pending application.
Yes.
You want argue to now?
The pending application is on the representation.
So, and that's what we are handling now. So
Letter we wrote on Friday to this court because it also contained some of these matters.
we also wrote a letter.
Yes, which is with the prisons authority. And they are here, maybe they can confirm whether they have brought it or haven't. Be on record.
So that one, so that they allow.
Been received.
I will go and report to you. I will go and report.
Superintendent of prison. For the letter in question, I'm Assistant Superintendent of Prisons, Hiro Emmanuel. Hiro Emmanuel.
Yes, about the letter.
My lord, all articles written to go through a verification process before they are forwarded. All articles written by the accused, they undergo a verification
Is
process.
this for what they do is still undergoing? That's what
I beg to confirm the status of the said letter.
So I'm not sure what's this for.
Yes, my lord.
I forgot to mention, excuse me, I forgot to mention, that we have also filed a notice to appeal your ruling. Appeal the ruling in our application to the and we again need the record of proceedings to proceed with that appeal.
So you are not so clear.
In the ruling of application number 227. That is the human rights enforcement application.
Okay.
Chief Secretary for prosecution. My Lord, in response to the issue of representation, the accused persons are represented by more than 25 lawyers. A1 and A2 are represented by more than 25 advocates. Scott Nakawa to this honorable court. My Lord, would appreciate the right of the accused persons to legal representation and more so by advocates of their choice. As envisaged under Article 28 of the Constitution, and Section 56 of the Trial on Indictments Act. Because it constitutes part of the fair hearing. My Lord, since the last sitting, A1 and A2 have been unrepresented. Unrepresented. And in his submission, that is our senior citizen and great statesman, Dr. Kizza Besigye, A1, he submitted that the lawyers were not in court because Senior Counsel Martha Karua, last time, even last time, yes, my Lord. Yes, I'm bringing my thing properly, my Lord. I'm rebutting it, my Lord, because without that I can't make my point. He argued that they were not in court simply because Martha Karua and... Yes, my Lord.
I didn't hear you talk about Martha and others. We first help court to address the concerns, their concerns today. Why this?
My Lord, it's going to help you in this matter very well.
No,
because I'm not going to do it much. Okay, my Lord. My Lord, we have never received any notice instructions from any of his lawyers. And actually, even the accused persons, that is A1 and A2, have equally not informed this court that he withdrew instructions from all the lawyers who are representing him since this matter started. So the assumption is that the instructions are still active. So therefore, when the accused person appears in court unrepresented the way he did last time, it's becoming habitual. And my lord, it is either express or implied notice to this court that they have waived their right to legal representation of lawyers of their choice. And my lord, this act is frustrating the hearing of this matter, because the principle fair hearing, or the issue concerning hearing, is not only about the accused persons. It is about the accused persons and other parties that are involved, including the public. My lord, ever since we did our last disclosure, which I think a month or plus ago, prosecution has been ready to have this matter heard. But we have been twisted always. And there has been a picture that has been painted to look as if prosecution is the one frustrating the trial or the hearing of this matter. We want to make it categorically clear that we have been ready to have the accused persons tried. Today we have witnesses and we came ready to have the matter heard. My lord, this in effect constitutes an abuse of the legal process. And my lord, if the accused persons are abusing the process, this court, my lord, has tools at its disposal under Section 17 of the Judicature Act to make a finding, my lord, among others, that the accused persons have waived the right to legal representation of their choice. My lord, Section 17. My lord, Section 17(2). With regard to, says, with regard to its own procedures and those of the magistrates' courts, the High Court shall exercise its inherent powers. A. To prevent abuse of process of the court by curtailing delays in trials my lord. Okay, most obliged, my lord. So, my lord, I will submit that make a ruling, a finding, based on that provision, that the accused persons have given up. They have waived that right to legal representation of their choice. The assumption, my lord, here is that under those circumstances, it becomes a voluntary waiver where most obliged, my lord. And my lord, the court in doing so, it can direct the matter to proceed for hearing. And in alternative, court can appoint lawyers on state brief to represent the accused person. It is our prayer that court makes a ruling to ensure that we have the matter tried. We are ready. Because if it doesn't, it's going to create anxiety in the mind of our witnesses. And some of them may end up not testifying. My lord, as the prosecutors or DPP, we are not party to application number 248 of 2026. Privy to it, and we are not aware of its contents. And my Lord, we are also equally not aware of the effects of the speech of the President in regard to this matter. My Lord, this court is independent and as per the Constitution, and this matter will be tried best
Are you responding
on
to
the
what
facts,
you didn't say?
on the facts,
He's
evidence
saying-
and the law.
He's saying
He wasn't allowed to say what he
didn't address that matter.
Most obliged, most obliged, my Lord. Most obliged, my Lord.
Yeah, but I said it is not here, so you
Most
can't.
obliged. My Lord, we so submit.
Want to give you
Yes,
an opportunity to respond in Lithuania or what?
Yes, very briefly, the application for it was filed last month. It was raised to the attention of this court on the 1st, on the 30th of June, when we came here to this court. Enforcement application. That we expected would be dealt with as a priority. If it had been dealt with, we would not have been in the dilemma we were on the 3rd. We would have resolved the issue of representation. It was not attended to in the hearing of 30th. It was not attended to in the hearing of the 3rd, in spite of raising it in both appearances. The circumstances that propelled that application were not of our own making. They were the making of the state. Which kidnapped Councillor Yasser Kwago and tortured him. And which arrested and deported Councillor Martha Karu. These were the actions of the state. Illegal actions of the state. If they hadn't been there, there would be no application 248. We would have proceeded normally. its basis, dismissing it. Regarding the lawyers not notifying prosecution, regarding their lack of instructions, that would be a matter for the lawyers to deal with. It cannot be visited on us. But suffice to say that both on the 1st of July and on the 3rd of July, in this open court, we did on the 30th of June, and on the 3rd of July. In this open court, we did put on record the situation of our representation. In their presence.
So, Doctor, this challenge, how long, according to how long can we wait on this debate?
If 248 can be had tomorrow and resolved, then the following day we will have a way forward. It hasn't been had since we filed it last month and talked about it in these subsequent appearances. Again, not for emphasis, since it seems Chief State Attorney Bill Mumbuka didn't get it. The disclosures were made to our lawyers. For us to receive them, we need the facilities through the prisons authorities for the lawyers to now make us access them. So whereas trial, and indeed they said they had a witness here on the 11th, they had a witness in court. But on the 3rd of July, they themselves read a letter written by the prisons authorities on the 29th of June. So we are supposed to hear evidence on the 11th, long before prisons considered to allow facilities to access the disclosures. By the 2nd of July, when that letter came to our notice, and I'm short their notice, the crisis of the lawyers had already emerged. So we have no way of accessing them since July the 2nd when that letter was written. And until the resolution of the legal representation which we are seeking. Regarding what he describes as abuse of process, then I think there must be completely different understanding of the judicial system, the legal and the judicial system we are following. Mr. Bilivumuka must be following the indigenous communities judicial system, while we are following the colonial or neo-colonial judicial system, whereas Mr. Museveni said includes the judges who are actors with wigs. Mr. Judge, the absence of our lawyers was occasioned by the state itself, not by ourselves. And it is the state that has progressively abused the process. It was the state which took us to the defunct military court-martial, military tribunal, which had long been declared unconstitutional. The state, the guarantor of the constitution, nonetheless took us there and charged us in an unconstitutional court, where we spent months. This court ordered for disclosures last year in December to be concluded by January. In a matter where all investigations were complete in May of last year. Yet from December, disclosures were completed in June. Our lawyers begged for sanctions against the state. Every appearance, we wanted the court to sanction the state for not following court orders. To hear our application to resolve the issue of our lawyers. we shall be ready to face their witnesses. As I ask for. Maybe what I forgot, you also talked about other parties which are inconvenienced by delays, saying we are looking at our own situation, not the situation of the other parties. The party, and this is a matter which you also touched on in your ruling on the human rights enforcement application. That those who apply for human rights enforcement seek to erase the rights of the victims. Our trial is of the nature that, because we are accused of treason, actions against the state. We aggrieve the parties, the state. And it is the aggrieved party violating human rights in this case. Coming with gripping hands to seek justice. So that our applications cannot be an abuse of a process, cannot injure the other party, because it is the other party that is injuring us. So
have very carefully listened to the concerns from the chosen persons and the prosecution. Report, I will not reproduce it. And for the interest of time, I will give a summary of my ruling, and I will avail to you a detailed one later. But briefly, the issue before this honorable court is the issue of legal representation. Today, the matter is coming for hearing. The prosecution told the court that they had witnesses around the court. And the prosecution said that they were ready to proceed. However, the accused persons, specifically A1, raised some concerns. Briefly, they are the concerns that affect the legal representation. To be specific, the concerns he raised is that, one, that there is a pending application number 248 of 2026, which is still pending before this honorable court, and is related to the issues of legal representation. According to the chosen persons, that is A1 and A2, they told the court that this application should be disposed of first. I will come back to that. They also raised the issue, the chosen persons, of the disclosure. The chosen person said that the disclosure was made to their lawyers, who have since voted the challenge. And for them, they have not received the disclosure. I will also come back at it. The accused persons also informed the court that they want to be availed with the record of proceedings in this case and the applications, which I will also come back to. Another issue of concern was that the facilities in prison, which prison wrote to this honorable court as of the 29th June, that the same be availed to the truth and their team. Another concern is by S3, who raised the issue that he was not given a copy of the ruling in his bail application. Briefly, I will now proceed to make the following remarks and findings on those summaries of the concerns. Of the debate provides for the right to a fair hearing. I will go ahead to Article 28.1. Article 28.1 provides that in the determination of civil rights and obligations for any criminal charge, the person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law. I have also considered Article 28(3)(d) of the 1995 Constitution. It provides that is 3D, that every person who is charged with a criminal offense shall be permitted to appear before the court in person or at that person's own expense by a lawyer of his or her choice. Indeed, from the time we started this case, the accused persons were permitted the lawyer to the services of the lawyers of their own choice. Not until 30th June and specifically 3rd July, when the lawyers of their own choice that had been representing them were not present in court. I will now go to Article 28, 3E. Article 28, 3E of the 1995 Constitution provides that, I quote, in the case of any offense which carries sentence of death or imprisonment for life, the accused is entitled to a legal representation at the expense of the state. In this instant case, and specifically the concerns raised by the accused persons, I will address all their concerns one by one for the interest of justice. Concern one, that miscellaneous application number 248 of 2026, which is allegedly to be pending before this honorable court, or specifically before me. Cases normally are allocated to the judges. Judges don't allocate cases to themselves. I want to make it clear that from my knowledge, miscellaneous application number 248 of 2026, which the accused persons are talking about, has never been allocated to me as a judge. It's not before me. But the registrar can find out from the registrar who allocates cases. But the said application has never been allocated to me, and the same application, I cannot use it or debate it to halt this trial, because it is not until that the same application is allocated to me that I would know the content. But at this stage, I don't know the content of that application, which has never been allocated to me, that I can form a mind to halt this trial in session number 335 of 2025. I will go to the issue of disclosure. The accused persons have told the court that the disclosure was made to their lawyers. True, from court record, the final and full disclosure was made on the 1st of June 2026. And I will take what the accused persons have told me, that they have never received such a disclosure since the disclosure was received by the lawyers who have since got challenges. I now order and direct the prosecution that for the interest of justice, at the end of this sitting, I'm ordering you make avail all the disclosure to the accused persons before court here on their own, since the other one, according to them, was made their lawyers. So at the end of the sitting, prisons kindly hold on, allow the prosecution to avail all the evidence they intend to use in this case, avail it to the accused persons themselves. In case there is any challenge of the prosecution to do that, serve all the evidence they told to rely on today, of which I believe, and I told court that they were available witnesses, I guess they had that evidence they intended to use, so avail it to the accused persons themselves. this case and other applications, I'm directing the Registrar of Criminal Division to avail the copies. In any case, the proceedings are by transcribing. So the IT should help the registrar to have these proceedings in this main case and applications, so that the registrar can certify them and serve the accused persons. This one can be done by tomorrow, which is 14th. And let the registrar, the IT, together with Ruzira prison, they should get these proceedings and avail them to the accused persons. I will now proceed to the facilities in Ruzira. As the accused persons, and specifically A1, 40, it is on record that at least by 29th June, the Ruzira people wrote this honorable report, and the letter is in record, that they had granted almost several facilities to the accused persons and their legal team, and directing Ruzira to adhere in the same. I want also to go ahead and comment on the ruling for S3, that it was unfortunate that you have not received a copy of the ruling. Yet this court directed the registrar and the Ruzira people to avail you with this ruling. I will now again direct the registrar and Ruzira people, even Ruzira people, before you go, make sure that you find out where it is, whether the registrar or the Ruzira, so that S3 is able to get his copy. For the interest of justice, and specifically to address the issue of legal representation, the chosen persons have been represented by lawyers of their choice as per Article 28, 3D, from the time we started this case, at the time of the pre-taking. However, it is my considered view that we are permitted to have lawyers of their choice from day one. But since this court keeps getting concerns from the accused persons that they have challenges with their legal representation, specifically lawyers of their own choice, this honorable court will move to look at the relevant laws. In case such a challenge keeps on, because my view is that there must be a solution for the trial to commence, and I am aware and alive of the right to the fair hearing. And my view, this case has suffered several delays, and indeed the accused persons have said they have been in remand for some time. So this honorable court has decided to invoke Article 28(3)(e), which provides that the accused persons are entitled to legal representation at the expense of the state in the cases of any offense which carries a sentence of death or imprisonment, life imprisonment. In the view of the above, the registrar, criminal division, is directed to avail a list of all lawyers in the criminal division for all the state brief, which criminal division has a pool of lawyers on state brief. So in order for the accused persons not to suffer with the challenges of the legal team which keeps coming, the registrar should avail to the accused person that list of all lawyers of the state brief in the criminal division. And then this list should be given to the accused persons through Ruzira. For the accused persons to look at this rule and choose as a fallback, choose some lawyers of their choice for the purposes of this trial. And this, the registrar is directed to do it by tomorrow 14th and send this list to Zira through the prison officers so that the chosen persons can look at this list of lawyers and be able to choose from them the lawyers of their choice. And this doesn't stop any other lawyer of the choice of the chosen persons to join the team of state lawyers, of lawyers of the state group. So the chosen still has a right to get lawyers of their choice, but in order for this trial to have a direction, let us have a list of lawyers of the state brief from criminal division, selected, chosen by a chosen persons themselves. In alternative, this trial, if the chosen persons don't choose the lawyers on state brief on their own and make their own choice, then I go ahead and make a direction that the registrar of criminal division by tomorrow, if the chosen person have not chosen from the pool, then let the registrar go ahead and appoint the lawyers of state brief to help court and the chosen persons to proceed with this trial. I'm invoking Article 28, 3B. In the same vein, for the interest of justice, if the registrar appoints the lawyers on the state brief, other than the accused persons choosing for themselves, then either way, if the accused person is selected and choose, and the registrar appoints, the prosecution is directed now to go ahead and prepare all the evidence they intend to use to give it these lawyers chosen by the chosen persons or appointed by the registrar. So the prosecution gets in touch with the registrar to know if the chosen persons have selected those team of lawyers, avail them with the evidence you intend to rely on. In conclusion, this case is adjourned to Wednesday, 15th at 11. Shall meet here and to know that the orders and the decisions of court has been clarification. Yes. Please let me put you on record.
Yes, please, on issues of clarification.
Just let me put you on record. Just a minute.
Which you have said is not before you.
That is number 248.
Yes, which is not before you. For us, we just make applications to the High Court. Now, this application very clearly directly relates to the matters before you. We have been presenting this matter before you since the 30th of June. The appearance of the 30th, the appearance of the 3rd. interest of justice, which you keep referring to, have you taken any interest to find out where this application is that relates to this matter very critically, and that fundamental affects our rights? Because once we file an application to the High Court, that's all that we can do, which we did. Secondly, I pointed out that we have filed a notice of appeal on the application, appeal on the ruling that you made. In respect of application number 227. Again, an application that fundamentally impacts on the main case. So we have an interest in continuing to pursue that application 227 in the Court of Appeal. And if the process of trial continues as you have guided, then sure our appeal will be completely negated. Thirdly, the schedule you have given us now did I get it correctly that, because I don't have anything to write on, as I pointed out at the beginning, we were arrested from the prison and brought here forcefully. First time I'm being arrested in prison. So we had to come prepared. But on the schedule, did I hear correctly that the disclosures will be available to us in the course of this evening? That tomorrow we shall get a list of government lawyers from which to choose. Or if we have difficulty choosing, the registrar will tomorrow appoint lawyers for us. And that in the same tomorrow, the appointed lawyers will receive the disclosures from the prosecution. And that then trial will begin on Wednesday. If what I heard and I have recounted is the case, then quite clearly the intention of this process is not a fair trial. Very clearly. Because you expect us to choose lawyers tomorrow, receive disclosures this evening. Disclosures, you say we receive them this evening, they will be given, but lawyers will get from them tomorrow. So clearly we shall have no time at all to sit with the lawyers, whether of government or otherwise, to review the disclosures, which as has been previously pointed out to you, are voluminous. And we should start a trial on Wednesday. Here, if such a process is insisted on, I don't see.
I think ask clarifications, then I will give. So don't.
So I come back after you have clarified.
You first tell me. Let me first know the clarifications.
So those are the clarifications, but the reason I'm asking for them is the concern that I am presenting. Or you want me to present the concern after you have confirmed or otherwise?
I'm saying let me get those clarifications. You said you have those clarifications you want, so I gave you opportunity to raise them.
Yes.